This is a presentation of the Lex Rex Institute, where we're committed to ensuring that the law remains our only king and that everyone is subject to it, even our leaders. I'm Alexander Haberbush, and I'm president of the Lex Rex Institute and also a practicing constitutional attorney. As always, when watching these videos, keep in mind that nothing we say here constitutes legal advice. All right, let's take a look at this week's question. In last week's podcast, you referred to lemon as a balancing test. What is a balancing test? All right, so shameless plug. For those of you who aren't already aware, the Lex Rex Institute has just released a new podcast. We're on our second episode. They're going to release on Monday afternoons, and I'm co-hosting along with our lead writer, David Truschel. We do recommend you look at those. Hope you enjoy it. We think they're pretty good, so give those a look if you haven't already at this point. But that's the end of my shameless plug. I guess in last week's episode of our podcast, I must have referred to, actually I know that I referred to the lemon test, and I must have referred to that as a balancing test, and I guess I didn't define that, which shame on me because you shouldn't use terms without defining them. So we're going to rectify that now by defining balancing test. So let's go ahead and look at the definition from Black's Law Dictionary. This is sort of the standard law dictionary. This is just to get us started. So Black's defines a balancing test as a judicial doctrine whereby a court measures competing interests and decides which interest should prevail. So you might have thought the balancing tests were what the police do to check your sobriety, and those might be balance tests, but balancing tests actually refer to something specific in a legal context, and notably they refer to the manner in which, or a manner in which, judges decide the outcome of certain cases. Balancing tests are one of the kinds of tests that judges will apply when looking at legal questions. The other main kind of test that judges apply is what's called a bright line test or a bright line rule. So what's a bright line test, bright line rule? Well, that's a much more objective rule that resolves a legal issue in a straightforward and predictable manner. Bright line rules tend to be very easy to administer. However, some people argue that they produce inequitable results in some circumstances. I'll give an example in just a couple of minutes, but as I've mentioned in many past videos we've put out, some of our articles, other content we've done, if you've been watching us much at this point, you're aware that Lex Rex Institute is not a big fan of balancing tests in a lot of different contexts. I'm not going to get into that too much today. I'm not really going to get into our criticisms of over-application of balancing tests. I'm just going to kind of explain what they are, leave you guys to judge whether or not think they're a good way for judges to decide things. And then I'm certain we're going to put out more content in the future addressing some of our criticisms of this as sort of the go-to way that the court resolves problems. So to use a real practical example, I mentioned last week in our Ask Attorney video that I think that a lot of times the best way to explain law is to use sort of a household as your example, because parents make a lot of rules for kids, a lot of rules get broken, just tend to work real well as examples. So imagine that there's a mother. Actually, imagine that you're a mother and you've got a few kids, and your kids are pretty noisy. You also work at home. You have a home office, you work out of the home office, and you don't want your kids to be disrupting your work all day. Well, there's two different ways that you could craft a rule for your kids, or at least two different ways, but we're going to look at two. First way is going to be a bright line rule or a bright line test, like we mentioned earlier. That would be something like when mom is working in her office, so between the hours of 9 a.m. and 5 p.m., let's say on weekdays. So between those hours on weekdays, none of the kids are allowed to come into the office. Now you can see where that might get inequitable in certain situations. Say that one of the kids is playing outside, trips and smashes his face, gets a bloody nose, wants mom to help him out. Well, under that bright line rule, if he goes into the office during the hours of 9 to 5 on a weekday, he has violated that rule per se. It doesn't matter if he's got a good reason. Say the house is on fire and he comes and violates the rule. You can see where, as we mentioned in the past, it's very, very difficult to anticipate every possible application of any rule. So if you have bright line tests like this, they can lead to inequitable results in some circumstances. So judges like to apply what's called a balancing test instead. So what would a balancing test look like in this situation? Well, that would be something like kids are not allowed to substantially disrupt mom's activities working in the home office. Now, I know most parents probably wouldn't use that language, but they might say something like, kids aren't allowed to cause too much of a disruption, or kids aren't allowed to be real noisy while mom's working. It's some kind of standard that's fuzzier, more of a boundary, gray area. Well, you might ask, what are the interests being balanced here? Well, implicitly, when you use phrases like too much of something, or that it's something that's excessive in the context, you're balancing one interest against another. In this particular context, you might be balancing mom's interest in getting work done efficiently, peacefully, against the kids' interest in playing, or maybe getting their schoolwork done, or fighting it out, boys being boys, whatever the thing may be, you're balancing those two interests against each other. And that may be a sliding scale that goes up and down depending on the circumstances. Maybe mom's got an important phone call, in which case there's a lot less disruption that'll be tolerated because her interest balance is higher in the equation. Or maybe kids have a school assignment where they've got friends over, and for whatever reason the school assignment requires them to be pretty noisy. Well, that might balance higher on their end of the scale. But you can see this balancing test requires a lot more judgment from mom on when the rule's been broken versus the bright line test that we discussed earlier. The bright line test, it was real obvious when somebody's broken. Anybody goes into the mom's home office during work hours, that person's liable. Under this bright line rule, kids may not know if they're violating this rule. It gives mom a lot more discretion. Mom has to do a lot more work, frankly, in figuring out whether or not the rule has been broken. So that's sort of how bright line tests versus balancing tests work. We mentioned in our podcast, the lemon test certainly is a balancing test. Now, 3 prongs of the lemon test where a statute must have secular legislative purpose, the principal effect must neither advance nor inhibit religion, and the statute must not result in an excessive government entanglement with religion. We had certain criticisms of those prongs in the lemon test, but you may look at those and say, well, what's being balanced here? Well, that's an important thing to keep in mind. Balancing tests do not always explicitly balance interests on their terms, but if you look at those 3 prongs, secular purpose, principal effect must neither advance nor inhibit, excessive government entanglement, all of those are matters of degree, and all of those require you, really, if you're going to answer those questions, to balance one thing against another. In this case, you're balancing the individual's interest in free exercise of their religion or free speech or whatever they may be doing with the state's interest in abiding by the Establishment Clause, not having an established religion. So that's sort of the way balancing tests work. One very, very common context in which you'll see balancing tests applied is going to be in a 14th Amendment equal protection context. So, as we know, 14th Amendment, one of the amendments that's passed right after the Civil War, and one of the clauses in that amendment says that states may not deprive any person of the equal protection of the laws. So this is where we get, laws cannot be discriminatory in their effects or in their intentions or, so on and so forth. Most discrimination lawsuits are going to be at least partially grounded in the 14th Amendment. That's where all this stuff comes into effect. And specific rules end up getting codified, giving different levels of scrutiny that are applied in different 14th Amendment contexts. Now, this is going to be particularly relevant to some of my clients. We've been getting a lot of calls lately about COVID-19 vaccination, and I'll get clients on phone calls say things like, at my workplace, only people who are unvaccinated are required to get tested for COVID-19 weekly. People who are vaccinated aren't required to get those tests. That's discriminatory. And they'll tell me that's discriminatory. They're right. That is discriminatory. Not all discrimination, however, is going to violate 14th Amendment Equal Protection Clause. Think about it for a minute or two. Any law inherently discriminates, right? If we have a law against murder, that law discriminates against people who are killing people with malice aforethought. We've got, any kind of law is at least discriminating against the subject of that law. So we've got to have some kind of tool to determine whether or not a person is being denied the equal protection of the law. And these tools end up getting proliferated during really beginning in the FDR era. You can imagine, you may be able to anticipate my criticisms of some of these rules based purely on that. But the FDR court, in hearing challenges to a lot of FDR's New Deal policies, ends up proliferating different standards for different levels of scrutiny. Let's take a look at those right now. So these are going to scale from bottom to top in terms of how difficult it is to meet the burden of proof, showing that the government's interest in whatever it's trying to accomplish is sufficient to outweigh whatever discriminatory effect a particular law is having. And just to be clear, 14th Amendment context is not the only context in which these levels of scrutiny will apply, but it is probably the most frequent in which you will see them. So rational basis review, as you can see, is by far the easiest for the government to meet. In fact, they don't even have to produce any evidence or make an argument showing that they have met it. If somebody wants to challenge a law that pertains to a class or an area of law that gets rational basis review, the person making the challenge has the burden of proof. They have to show that that law does not meet rational basis review. Then at the very top, the absolute hardest for the government to meet is going to be what's called strict scrutiny, and then intermediate scrutiny falls in between those two. Now, most of the time, people bring 14th Amendment challenges, or any challenge that could have different levels of scrutiny that applies to it. You'll see that the vast majority of the arguing between the two parties on those cases is going to be about what level of scrutiny applies. Because once that question is decided, it almost decides the issue for you, because strict scrutiny is really, really hard to meet, almost never gets met. So laws that require strict scrutiny almost always end up getting overturned. Those laws end up getting reversed. The court will not enforce those laws that Congress or a state has passed because strict scrutiny is very difficult to meet. Whereas if it gets rational basis review, the law is almost always going to be upheld. You're almost never going to overturn a law that is heard on rational basis review. Now, whenever analyzing any of these levels of scrutiny, the court's going to look at two different things. And the first thing the court's going to look at is how important is the interest that government was making laws about. And then the second thing is how closely tailored was that law to advance that particular interest. So as we know, you could have laws that are very, very broad, and they end up including way more activity than what they actually wanted to control. You can also have laws that are very, very targeted. So let's say a government decides they want to prevent alcohol from being advertised on billboards. Well, they can go about that two different ways. There's a narrowly tailored way, and then there's a way that's much broader and would encompass more activity. So first way, narrowly tailored way, might be to say that it's prohibited for anyone to place content on a billboard that either depicts via picture or text alcohol or the consumption of alcohol with the intent that a viewer would be induced to purchase alcohol from seeing it. That protects pretty much just what the government wants it to protect it by prohibiting the activity that is actually directly in question here. It might be under-inclusive, actually, because people could still put pictures of alcohol on a billboard as long as you can't prove that they were intending that to induce someone to buy it. Well, the really broad way that you could phrase that is to say something like, no company that produces alcohol may place materials promoting that company's products on any public thoroughfare. Well, that's very broad in two different ways, right? Because the first way, any company that produces alcohol. Well, companies that produce alcohol might produce a whole lot of other things, and you're preventing them from advertising those things too. And then on the second end of that law, it says anywhere in a public thoroughfare. So that doesn't just apply to billboards, that would apply to ads on the sides of buses, those ads that are at bus stops. It would apply to things people post in windows of liquor stores. It might even apply to things that aren't ads, for that matter. Could be pretty broadly, actually, that might be unconstitutionally vague even. But as you can see, two different laws. One of them is narrowly tailored to serve its purpose. One of them isn't. So that's sort of what we mean when we're talking about that. Those are the two different things we're going to look at in analyzing each of these. Is going to be the importance of the interest and then how narrowly tailored that interest is to its objective. And for strict scrutiny, the court's going to say that it must be narrowly tailored to serve a compelling state interest. So narrowly tailored to a compelling state interest, again, the highest threshold that you're going to have to meet on any of these. Intermediate scrutiny is closely drawn to an important interest. You may also hear this one as substantially related to an important interest. It might sound really, really similar to you to the narrowly tailored to a compelling interest, the strict scrutiny standard. The court does apply these very differently, though. It's much looser on the intermediate scrutiny standard. And then rational basis review is going to be rationally related to a legitimate state interest. So as we mentioned, it's a very low bar. I mean, virtually any law can be rationally related to the objective the government's trying to achieve. And what's a legitimate government interest? Well, virtually anything the government wants wants to do is going to be a legitimate interest, at least at this phase in our history. Courts have accepted almost everything as the proper purview of government. So, virtually anything is going to be a legitimate interest at this point. So, purposes of all of these, what sorts of things are going to be government interests? Well, I'm not going to voice my opinion on which ones are compelling or important, but I'll give a few that are legitimate, and then obviously the more important those are, the higher they would fall in the level of scrutiny analysis. But it'd be things like advancing healthcare might be a state interest, or protecting the environment, or providing for social welfare, or any number of things, protecting kids from getting drunk. You can think of any number of things that the court's going to recognize as a state interest. Are all of those things actually state interests? Well, that might be debatable, but at this point, courts recognize most of them. So that's the way the different levels of scrutiny work. Now, which sorts of things get each level of scrutiny? Because we know that, how do you decide which things fall in strict, which things fall in intermediate, and which things are going to fall under rational basis review? Well, let's take a look at the next slide. So for strict scrutiny, we're going to get what are called suspect classes. And the court has only recognized a few of these. Those are going to be race, national origin, religion, and alienage. Only one of those that might not be self-explanatory is alienage. All that refers to is whether or not somebody is born in the United States. Now, this is just going to be for legal immigrants, where alienage is a suspect class. For illegal immigrants, that's going to fall under rational basis review. Now, quasi-suspect classes are going to get intermediate scrutiny. At this point, that's pretty much just sex and gender, but the court has made some overtures toward recognizing sexual preference as possibly the proper recipient of intermediate scrutiny. I'm not going to voice my opinion on that right now. They haven't gone all the way in that direction yet, but that is a possible thing to look for on the horizon. And then as far as unprotected classes go, those are the ones that get rational basis review. That's going to be everything else. So other categories you might think of be things like age, disability, wealth, political affiliation, political views, whether or not you have a criminal record. All those different things are going to be unprotected classes subject to rational basis review. So to answer my client's question about whether or not his employer, assuming their employer is a government agency, a state agency, whether or not their employer can discriminate against people who have been vaccinated versus people who have not been vaccinated, well, as long as what they're identifying as the basis for requiring people to get tested or not is simply vaccination status, it's probably going to get rational basis review, because whether or not you've received a particular medical treatment doesn't fall in either those protected, the suspect or the quasi-suspect classes. Now, if you can show that that employer was actually motivated by discriminating against somebody's religious beliefs, since a lot of people do have religious objection to vaccination, then it's going to be a different story. But if it's just the disparate treatment, if it's just that they're discriminating against one group versus the other group, that's true, but it's probably not something the court's going to remedy in most cases. So that pretty much covers our question for today in terms of the way that the court will handle balancing tests, and then specifically 14th Amendment balancing tests. Hopefully you learned something. Usually we try to relate these videos back to a case we're working on. These are kind of abstract theoretical things that really apply down the road when a case goes to appeal. So I don't know that we're addressing any of these directly right now, but the Lex Rex Institute does address each of these things, or this subject matter, very broadly in all of its cases, really, because we don't believe that your rights, your constitutional rights, should be balanced against any government interest. I think it's totally outrageous to say the state's interest in accomplishing any of its goals outweighs something explicitly protected by name in the Constitution of the United States, and we will fight against that consistently. So that's if that's something that you feel motivated to donate to, please check out our website, lexrex.org/donate, and make a contribution there. Really, any amount helps, even if it's $1. That pretty much concludes everything we got to say for today. We'll see you all again next week, I guess. Thanks for watching, and have a great weekend. Oh, and I'm supposed to mention, if you like this video, be sure to click like. If you really liked it, hit subscribe, and click on the bell icon for notifications. All right, thank you very much.